So a copy of the form that you fill in to give to
We're ready for the afternoon session.
you know about that. But what most people don't know is that you also get
Thank you, ladies and gentlemen. It's now my pleasure to introduce Joyce Plotnikoff, who's going to talk a little bit about intermediaries in England and Wales that we touched upon before, and what messages or lessons might be learned for the developing role of appropriate adults and other matters. I'm not going to read Joyce's CV, partly because it would take up all her time, I think, if I did that. But she has been a major name in the field of child and vulnerable witnesses, both in the UK and abroad. I want to mention one particular aspect that Joyce was involved in at its instigation, which is called the Advocates Gateway, which has already been mentioned today, a fabulous series of what are described as toolkits to assist advocates in England and Wales in properly and sensitively cross-examining witnesses. And it has been a terrific success, which other jurisdictions are looking at, as a way of trying to take us away from the adversarial system. And as I say, that's why it's so encouraging to hear about the kind of collaborative approach that the Solicitor General mentioned in the trial involving the 8-year-old witness. But Joyce is going to share her experience and her thoughts with us in advance of the roundtable discussions we're going to have. So, Joyce, thank you very much.
Thank you. I can't tell you how appreciative I am about being here as a Scot. I love being asked to come back and speak in Scotland. And to thank the organisers for a free conference. This is unheard of these days, and it's been so important to gather the people who are here today. I thank them also for putting me in the graveyard slot. And to keep you going, you're going to have to wonder why I have a green squeezy frog up here with me, but we'll come to that. So hang in there. I evaluated the intermediary pilots when they were introduced in 2004. National rollout was 2008, and I'm in almost daily contact with intermediaries. And last year we wrote a book about it, which is really a kind of behind-the-scenes story of intermediaries in the justice system. There's some good anecdotes in there. But to start out with the legislative provision that underpins them, it's important to explain this because it explains why starting where you are now in Scotland is so important about not getting it wrong the way England did. You will see the bottom line, as has already been mentioned, the legislation excluded vulnerable accused. You'll forgive me for using the word vulnerable because I know it can be a sensitive issue, but it's what the legislation uses, so I will be using it as shorthand. Eligibility in the English Act is anyone up to the age of 18, adults with learning or physical disability, and I highlight physical because I think that's something that gets overlooked sometimes in Scotland. There are many types of physical disability that can affect communication or mental disorder. The test is the same as in Scotland for special measures, complete, coherent and accurate. Accurate is a really important word when it comes to intermediaries because they're trying to facilitate accurate evidence. The programme under the Act is that the Ministry of Justice set up a register, so they recruit, they train, and they match. There's a matching service for appointments. If the police or the prosecution or a defence solicitor for a vulnerable defence witness can apply to the register to get somebody whose skills match the needs of the person that the application is for. But there we are, we're left with a system excluding the accused. So what happened immediately is that judges said, not a level playing field, we're going to make these appointments anyway. And that has been happening since 2009. I can't tell you numbers because it's not monitored, but certainly into the thousands of appointments. Most appointments, nearly all appointments, have been for the whole of the trial process and pre-trial hearings as well. A few have been for evidence only. And if you have got somebody who's got a cleft palate or Parkinson's or a stroke or something that's not affecting their understanding but is affecting how well they're understood, then it's appropriate to appoint somebody just for evidence only. But if there are cognitive difficulties, other issues to do with understanding, then judges have been saying, we'll appoint for the whole trial. We have a government provision in the 2009 Act for evidence, restricted to evidence only, but that's not been implemented. And the whole of this issue has been about cost, really. Even that restricted appointment has not actually been put into practice. So the current position is, to use that lovely word, a guddle. It was a good word when I was a child. I presume it's a total mess. The Law Commission this year said this is terribly unfair, it has to be put into statute. And they very cleverly have said, well, the test should be that you appoint the intermediary for as much of the process as is necessary to achieve a fair trial. It's under consideration, but we've had a setback in the last few months because the Lord Chief Justice has issued a practice direction saying that appointments for the accused should be rare. This has put judges in an incredibly difficult position. I think it's almost inevitable that this practice direction will be judicially reviewed, and you will see that it actually conflicts with some of the other guidance that's in criminal procedure rules, which have a higher status than the practice direction. So it's more of a mess than ever. And it's why what you're doing in Scotland and looking at provision across witnesses and the accused is so important. But that's my first message. Don't do that. So what does an intermediary do? They are independent. They are communication specialists, whole range of backgrounds, and they assess the person and provide a report and recommendations. All of this is underpinned by the need for training, obviously. But can I say here there's an issue about the word support, which is used a lot in what we've been talking about this morning and in documentation. Intermediaries try to avoid saying that they're supporting communication. They say they're there to assist because they don't want their role to be confused with that of a supporter. They are not on anybody's side, they are there to help the whole process. Every appointment begins with assessment. And it's worth thinking about how that has developed. The assessment is very much geared to the criminal justice process. It will be a non-evidential discussion, and it will be based on the person's own interests. It's not going to be about the case or the evidence. So one of my favourite examples is an intermediary asking, well, what is he interested in? To which the answer was, pornography. And she thought, I don't think I can do my assessment on pornography. What else is he interested in? Killing flies. Okay, that's fine, I can do this. So she went to the assessment with pictures of flies, ways of killing flies, threw in a few wasps and bees. But she was able to do an assessment of the person's communications. So it's very much geared to the person's interests and what the system is going to need. So they're going to be looking at the person's understanding of time, of sequencing, of descriptions, if that's what they're going to be asked about. And particularly, are they able to give reliable answers to leading questions? And so I had chips and cheese for my breakfast, didn't I? Or some sort of ludicrous things they'll have conversations about, but they will try to see whether the person is going to agree with them or not, and particularly if questions are repeated. And they will also try and see if the person is able to say when they don't understand, because we know, and it's good practice always to ask people if they don't understand something, but then we tend to assume that they do, and I'll show you an example of that later. And the issue about whether people volunteer information about their communication problems, I think, is something that intermediaries are very sensitive about, because quite often the people that they meet have not been diagnosed with a problem. It will be that a police officer or a solicitor has spotted that there's something that's not quite right, but they don't know what it is. And the person themselves naturally are going through life being as capable as they can be and not wanting to have labels attached. So it's actually quite unusual, I think, for people to come in to an intermediary assessment with the intermediary knowing what any diagnosis. There might never be a diagnosis. Intermediaries will also go along, by the way, on court familiarisation visits, which are a routine part of the process for a witness. I think it's quite unusual for an accused, but it's a really important way for the intermediary to see how well somebody might cope with the court process and how they would give evidence. Right. So you'll see in your packs that there's a piece of paper that looks like that with tick boxes if you want to have a look at that. It's my terribly primitive basis of trying to compare appropriate adults and intermediaries. Now, I'm tentative not just because obviously I've got limited knowledge of the appropriate adult system, but also, as I understand it, because the role is very different around the country. And I've drawn here from the guidance from the Scottish Appropriate Adult Network. Now, you will see there is some overlap, but there are also fundamental differences. Appropriate adults assist at police interviews for vulnerable accused. Intermediaries don't, and that's largely because they're operating in an unregulated role at the moment, and it's rarely possible to get funding. You might want to look at Northern Ireland, where the Northern Ireland Intermediary Scheme has learned from the problems in England, and they have included work with the accused in their pilot programme. Intermediaries are more actively involved at the trial stage than appropriate adults. And I think for me there's a question mark about children, because I know that children here would be the responsibility of a responsible adult. But again, I think different criteria in terms of communication responsibilities. So I think that's a real issue for Scotland. The sole user group would like to see support from somebody who can't be called as a witness against us. And for me, that's a fundamental difference between appropriate adults and intermediaries. It's acknowledged in the guidance that an appropriate adult has the potential to be treated as a witness. This is strongly resisted in respect of intermediaries. Incidences of actually being called as a witness might be unusual, but I think that difference is a real constraint on how the role can be developed. Much of an intermediary's work is done behind the scenes. Their presence during questioning is still important, but many people would say that the work that they do in helping both police officers and lawyers design their questions or inform them how to simplify their questions has become more important, because it can help ensure that questioning is right the first time round. Because many of you will know that by the time you intervene to say that question isn't developmentally appropriate, actually it's too late for the vulnerable person who've already disrupted the communication. And again, another lesson, this advice role was not anticipated at all when the scheme was first envisaged. It was only thought about as being the person who sat alongside the witness at court. But it's become something that's terribly important. So just saying something briefly about how are the intermediaries for the accused working. There isn't any direct authority in respect of legal privilege, but in terms of what was said this morning about disclosures, and so I suppose this is really should be disclosed to the defence lawyer, but not the prosecutor or the police. But that's the way it's operating at the moment. So, because they're unregulated, how does an intermediary for the accused, what's the framework they're working in? They're working in a framework of criminal procedure rules and practice directions, which put the same expectations on what is done for witnesses and a vulnerable accused. And the phrase "every reasonable step" has become terribly important. I would get the T-shirts with it on. I will show you how valuable those three words have been. Every reasonable step to facilitate effective participation. It rolls into radical departures from traditional cross-examination, but it's also further than that, we will see. So there's a shift in the expectations on lawyers and judges. There's a shift in terms of preparation. And that's ground rules hearings, which I'll talk about in a second, and the Advocates Gateway toolkits, which the Sheriff mentioned. Because you can't have an intermediary in every case where you have a vulnerable person. So this is online free guidance about how to simplify your approach to questioning. And again, a very new thing for the judiciary in England and Wales, there's an expectation that you will prevent questioning that fails to comply with the new guidance and anything that's been established in ground rules. So it's true that ground rules hearings started out in the cases where intermediaries were appointed for witnesses. They've now been extended into any case with a vulnerable person, even if you don't have an intermediary. So this has become the norm, that there will be a planning process. And it's looking not just at questioning, it's focusing on the questioning, but it's also the timetabling. Do you need communication aids? Are there things that need in the whole trial process to be modified? If you've got co-accused, are there going to be, this is for witnesses, are the co-accused going to, the counsel be limited to not asking repetitive questions, but allocating the topics? All sorts of things about managing the trial process. And there's a lovely example in the case of Cox, where a judge wanted to appoint an intermediary, was not able to get one. And he said, well, I'm going to issue ground rules that will be the equivalent, and one of these things is going to be that I will want every witness to be asked simple questions, and I would ask every witness to give simple answers to the best that they can, so that the accused can follow what is being said. And the Court of Appeal thought that was a great idea. So this is just, judges like ground rules, because we know that it's actually very difficult for judges to intervene while questioning is going on. It's easier for everybody if the expectations are clear at the outset about what is required. One of the things in policy that has been enormously helpful has been guidance about tag questions. Now, this is, ground rules hearings were borrowed from California. This guidance was also borrowed from America, from the American Bar Association. And while it was introduced in terms of children, it's now become more generally relevant, recognised as being relevant when you've got anybody who's got certain vulnerabilities. That the he didn't do it, did he type of question is actually very linguistically complex. And of course that's one of the reasons I think why they're used. It's very persuasive. If any of you are interested in these slides, you've got my email on that piece of paper. Please email me and I'll send them to you. This is just what's in the American Bar Association guidance about just how difficult it is in terms of the linguistic complexity and the pressure of the suggestion. So, because this is in guidance, intermediaries will assess somebody's ability to deal with this type of question, but it's a relatively common ruling now for judges at ground rules hearings to say, based on the assessment of this person, no type questions. So what other sorts of recommendations do they make? Again, not one size fits all, it's going to be tailored to a particular person, but very typically these are the sorts of things that you will see for anybody with a communication need. And the issue about pace, I think, having observed in courts for years, is one that's often overlooked. That even if questions are short and simple, they're often far too fast. The pace of questioning is actually quite difficult when people need time to process the question. The intermediaries will now invite advocates to provide questions in advance. It doesn't happen all the time, but it's becoming more common, and again, it's something the Court of Appeal has actually upheld. So if judges direct that this should happen, it's entirely reasonable. And in fact, in that particular case in RL, the lawyer complained that his cross-examination had been emasculated, and he used some other quite strong language. The Court of Appeal didn't agree. Communication aids, right. The frog is coming now. Lots of people need help with communication because communication in interview and in court does not need to be entirely oral. This is an example about structuring and signposting. If you get the advocates to say, well, what are the topics you're going to ask about? An intermediary can make a visual reminder that can be in front of the person. So there might be several sheets like this, but then the person can kind of tick off when the questions on the topics are finished. It's a way of helping them control what's happening. There are lots of examples of these kinds of things. Being able to show and not just tell what happened. So these kinds of aids are used with the accused giving evidence as well as with a vulnerable witness. And this was made by an intermediary in consultation with the police about where things happened in a public toilet, because it's easier to point perhaps or to say, please provide more pictures of this rather than ask somebody to describe it. Timelines. And these are used with witnesses and the accused, particularly where you've got offences, alleged offences over time and in different places. And the tendency often in questioning is to jump about, and it's very hard for people to follow what they're being asked about. So it could just be something as simple as, while questioning of other witnesses is going on, the intermediary in the dock will sit and put yellow stickies on the dock in a time sequence, just so that the accused can follow. But if they've got an opportunity, they can make a visual timeline with somebody ahead with the with the lawyers ahead of time, and it's entirely factual. This is nothing about the case, but it's where the person was at particular ages or times or physical locations. And those, obviously, any type of communication aid had to be agreed by the court, but these are routinely agreed. Where you've got somebody who needs a reminder about the rules for answering questions, it helps if you can have a visual reminder, again, that's tailored to the person's interests. This is a young woman who's a Lady Gaga fan, and she had a tendency to rush her answers. So this is Lady Gaga reminding her to take her time. Again, the jury is shown these things in a package ahead of time, but the judges agree they're used, tailored to what's the person's need if they need to slow down and take their time when they're answering questions. This is something I think is of interest because, as I understand it, even the more involved appropriate adults, I think, have not been involved at this point because of these difficulties about being potentially a witness. Intermediaries, if they're appointed for the whole trial, will be involved in helping to take instructions. And lawyers are very positive about this. This is a barrister saying, I thought I was more than capable. But in fact, the intermediary was very helpful. Intermediaries might be making a flowchart, for example, to explain the consequence of pleas, or explaining vocabulary. Is a similar one from a solicitor. So helping to ensure that instructions are taken appropriately is very helpful. And again, because there's no evaluation of this, I have no figures, but certainly I hear that intermediary involvement has resulted in some guilty pleas being taken at this stage where somebody had not previously actually understood what they've been charged with. So, case example, this is an intermediary with somebody who is deaf, and we have some intermediaries who are deaf themselves, but they're not just a sign language interpreter, they are intermediaries, different role. But in this case, the sign language interpreter said this man actually doesn't even use conventional sign language. They needed to spend a lot of time working on his communication. And the intermediary was able to do something that a sign language interpreter couldn't do, which was to help go through statements, and I think in this case some of the witness statements were contradictory, but explaining what was in each of them, but doing it visually, drawings, diagrams, figures, and then with the lawyer having the accused act out what he said had happened, which helped inform the taking of the instructions. But that took a week, I think, to do. So when you get to the trial process, the accused sits with, if they're appointed for the whole trial, they sit alongside the accused in the dock, they take the oath, it's explained, etc. They may help contain the accused emotionally. I'll explain that with the aids, but I think there's a very interesting thing, and again, not anticipated, about just how difficult and confusing and distressing it can be for some people in the dock. And an intermediary is not their primary role, but it's a side benefit. And the issue about the giving evidence actively to intervene when communication may or may not may be likely to be occurring. So I said I would give you an example. I'm making the assumption that the accused is agreeing. Yeah, I understand. Yeah, it's all right if you assume that I understand. The intermediary says, no, Miss X may not understand the word indicate. And the judge goes along with that. I'm going to assume that you understand if you don't say anything. Again, accused agrees. Judge. But finally, the penny is dropping with the prosecutor. So it's a really good example for you cannot rely on somebody saying, and especially not in court, where it's so difficult to say, I don't understand. Right, every reasonable step. Large print, giving the accused the judge's direction, anything the judge is saying that's prepared in advance in large print, sometimes giving questions ahead of time in large print, enlargement of evidence photos, allowing an accused to give evidence, an accused with autism to give evidence behind a screen. It was a case where he was feeling intimidated by the co-accused in the dock. Allowing the accused to have adult colouring books because he was so distressed it stopped him hammering on the screen of the dock. So that the intermediary negotiated that. And this is where the quiet, calming, fiddling objects come in. Intermediaries have a whole repertoire of fairly disgusting things that you can hold in your hand or twiddle with, because they find that that is enormously helpful in containing people emotionally and enabling them to focus. But this disgusting frog is one of my favourites. You have to make sure they don't explode. Sometimes really awful things can happen when they explode. Somebody with Tourette's being allowed to whisper to the intermediary all the way through the trial, because otherwise he'd have been shouting out obscenities, so he just whispered them to the intermediary instead. Old Bailey case, allowing an accused to practice walking to the dock, having his favourite music played and answering mastermind subjects, type his favourite subjects in from the dock, so that he got used to the idea of answering questions from the dock. Again, it was somebody with autism in a very serious case at the Old Bailey, but it enabled him to give evidence. Somebody in the dock where the intermediary, and this one is a dock with a glass side, is aware that people in the public gallery are making faces at him and he's making faces back, getting the side of the dock blocked off. So managing anxiety, especially important in these situations, and recommendations are often about this. And of course, because anxiety affects community that people could point to, it's better if they make their own, and you can see the one on the left is going to explode at the top. The intermediary can check with the person periodically when he's getting halfway up the scale. The intermediary can say to the court, time for a break. Other sorts of aids, things to point to, whether you need a toilet break or to pause. One last case example, and this is a really interesting one because to me, not knowing enough about it, I'm thinking, is this person actually able to give evidence at all? But he's an accused with an offence of violence and a whole range of difficult behaviours because of his psychosis. All of this affecting communication. Very, very stressed as the trial comes up. The intermediary explains that the ground rules hearings, asks for pauses, and asks for a quiet room that he can use in breaks. There's lots of breaks built in, more if she needs it. A little bit of the break set aside for the solicitor to explain things. She gets permission to do pressure pointing and tapping to try and help distract him. I mean, normally touching between an intermediary and a witness or accused would be a no-no, but this was a specific need tailored to what his requirements were. By the time he's giving evidence, he's seeing alien lights and he's standing in the witness box swaying because he's avoiding the lights. So the intermediary asks for a break, which stopped the lights. He was able to go on. And this whole trial was managed, I think, on the back of these recommendations. Now, as it happens, he was acquitted, but it meant that it was a fair trial for him. And it would have been a real challenge, I think, for the court to manage. And I have to put this one in because people are beginning to ask for dogs to come with a vulnerable person in the police interview and at trial, but one judge has let an accused bring his cat in the shopping trolley. So, but it's amazing what pictures you can find on the internet. So, what's the impact been? Enormous, and I think this slide is the one to take away. 2/3 of the judges we interviewed for the book, 78 judges, I think, said they changed what they do as a result of working with an intermediary. So, messages. Name for a new profession. Intermediary is a dreadful name. Nobody knows what it is. But I do think you have to think carefully about what you call people. There will be confusion about the role. I think it's difficult to say this is a new profession, this is a new job. It's not like what anybody else has done before. The regulation obviously is vital because we've got into such a mess without it. Has to be something that applies to young people as well as adults. Recruiting people, you will find when you look at this, communication skills is not enough. Has to be people who feel confident to put their hand up in a courtroom or to speak to lawyers, resistant lawyers possibly, outside court about what their role is. They have to be supported, which we do not do. We do not do well. Very high turnover because it's such a stressful job. There's a huge investment in training intermediaries, which we could reduce if we could retain them longer. They highlight the training need, not just for themselves, but for people across the system. And once you actually have it in place, it creates a demand for the role elsewhere in family cases, in tribunals, all sorts of, anywhere that you might have somebody with a communication need, and as we know, that's everywhere. And judicial leadership has been essential, which you already have. So in the handout there's information about the toolkits and also some other resources. And I'm only just a teeny bit over time. Thank you very much.
Thank you very much indeed, Joyce. That again flowed very nice. I think the flow of the day has been very good. Lady Dorian talked about effective participation, and Joyce has talked about the need for it to be tailored to the accused and the need for every reasonable step to be open, and I think that's good for thought. We're now moving on to the round table discussions. As has been mentioned, on each of your badges there is a number, and the number reflects the table that you have to go to. I don't know if you have a list, Tony, of who's to go where.
5 and 6.